Good morning, everyone. Today, let's dive into a really interesting and very current topic from the constitutional law. So, the presidential reference under Article 143 of the Constitution. You may have heard in the news recently that President Draupadi Murmu sent a set of very important constitutional questions to the Supreme Court. But what's really happening here? And why is this important for us as as a students who are appearing for UPSC examinations? Let's break it together. First, let's start with the basics. First, let's see what is an Article 143. So, Article 143 gives the President of India the power to refer important question of law or fact to the Supreme Court for its advisory opinion. For its advisory opinion. The idea is simple. When there is a confusion or a major constitutional doubt, the executive can ask the judiciary, hey, can you clarify this for us? Something like that. But, and this is a big, but the Supreme Court is not bound to answer. It has the discretion to say, sorry, this question is too vague or hypothetical. We won't want to answer. Something like that also they can say, because in Kerala Education Bill 1951, where the court said that it can choose not to answer if the issue is too abstract or not justiciable, or it will be little have come hypothetical factor into the question, right? So what happened is the President Mumu has referred 14 questions to the Supreme Court. These related to the roles and responsibilities of the governors and the president when it comes to state bills, especially those reserved under Article 200 and Article 201. Right? So before we jump into those 14 questions, let's look how this even works, right? But wait, first of all, can the president act alone? Let us try to understand this question. Absolutely, the answer is no. Because under Article 74(1), the president must act on the aid and advice of the Council of the Minister. So, technically, even though the reference goes out in the name of the president, it's actually the Union Cabinet which is sending. So, these questions to the Supreme Court. And immediately, if you can go through Article 74(2), it protects this advice from the judicial review. But in SR Bommai versus Union of India case, the court clearly said that while we can't question the advice, that's fine, but we can look into the factual background to ensure the decision, the recommendation is not arbitrary. So that's a big safeguard, which means that the judicial review is still applicable on the material which prompted this Council of Ministers to give such kind of an advice to the President, right? Now, let us see Article 145 Clause 3. So that is very important clause as well. So this one is very interesting because Article 143 Clause 3 says that if the Supreme Court is deciding a case that involves a substantial question of constitutional interpretation, right, or a presidential reference especially, at least 5 judges must sit on the bench. That is a rule. Understood? That is a rule. So minimum, whenever the president is asking a question or whenever there is a substantial question of the constitutional interpretation, the Supreme Court has to constitute minimum 5-judge bench. That's how the serious important these questions are. Right? Now, the key questions which raised by the President Draupadi Murmu, let's see that. Number 1. What can a governor legally do when a bill comes to him? Because so basically under Article 200, the governor can give assent or withhold it or reserve it for the president or send it back once for the reconsideration. But can he just sit on the bill forever? We don't know. So that question was asked. The second question, is the governor bound to follow the advice of the state's Council of Ministers? Generally, yes. Under the Westminster model, And also under Article 163, the governor must follow advice except in very narrow discretionary situations. Where he is finding such a discretionary situation arises, he has some authority to act on his own despite on the advice of the State Council of Ministers. So the question is very clear. Is the governor bound by the aid and advice given by the Council of Ministers while exercising all the options available with him when a bill is presented before him under Article 200 of the Constitution? The third important question is, can the governor decision under Article 200 be reviewed by the courts? That is a justiciability question. Because while Article 361 clearly says that the governor is not answerable to courts for official acts, the courts have often looked into whether his actions are constitutional. Even we have recently seen in Nabam Rabia case, where the Supreme Court interfered in the matter, right? Another question is, in the absence of the constitutionally prescribed time limit and the matter of exercise of the powers by the governor, can timelines be imposed by the judicial orders? Because this question and this question is almost similar. If the Constitution does not say how long the governor or president can take to act, can the court impose a deadline? So this question is really interesting, right? The Constitution is silent on this. So can the judiciary step it under Article 142 and say, hey governor, sign it in 30 days? That's what being asked actually by the Supreme Court. So these questions are really confusing. And if you can see some of the other questions, in the light of the constitutional scheme governing the powers of the president, is the president required to seek the advice of the Supreme Court by way of reference under Article 143 of the Constitution and take the opinion of the Supreme Court when the governor reserves a bill for the president doesn't otherwise? This is also a very, very interesting question which is asked by the court. The ninth important thing is the governor who is taking actions under Article 200, the president who is taking actions under Article 201, right? The decisions are justiciable at a stage anterior to the law coming into the force. Is it permissible for the courts to undertake judicial adjudication over the contents of the bill in any manner before it becomes the law? That's also a serious question. And if you can see a 10th and 13th questions, those are almost similar. Can the Supreme Court replace or override the decisions of the president or governor using its power under Article 142? So this is a very deeper question. How far can Article 142 go? Can it be used to issue substantive orders that clash with the Constitution or laws in force? Or it is just for the procedural gaps? That question needs to be answered, right? And if you can see an important question, can union state disputes be decided only under Article 131, or can other jurisdictions like Article 32 or Article 226 can be used? So this touches the heart of the federalism actually, because does only Article 131 apply when states and center are in conflict? Is there no other article like Article 32 and Article 226? That is also be in the substantial question, right? Now the big picture, why does this matter, right? So you might ask, sir, why is this such a big deal? Here is why. Number one, it tests the checks and balances, right? So these questions actually forcing the Supreme Court to look into the checks and balances of the democracy. Number two, it challenges the boundaries of the judicial review. It challenges the boundaries of the judicial review. So that's why these questions are important. The third one, it raises questions on delays by governors and presidents which can stall laws. So it is telling that what is the maximum power of the governor or what is the maximum power of the president under the democracy, under this parliamentary democracy setup. Number four, it touches the federal structure, which means that the center-state relations are hugely going to affect it. Because till recently, we've seen that most of the time the governors are acting as agents of the central government rather than acting independently, rather than acting as a friend philosopher of the state government. So if the Supreme Court answers these questions, it is going to give a certain kind of the understanding of the federalism structure in India, especially center-state relations. And finally, it also tells that how far the judiciary can go to fill the constitutional gaps. These are all can be done. So now remember, Article 143, opinions are advisory only. Understood? They are advisory, they are not binding. But let's be real, the Supreme Court's view carry enormous moral and legal weight because of their perfect reasoning. They often shape future laws and executive conducts. So keep an eye out. This reference might set the stage for some very important constitutional reforms or judicial doctrines. And maybe, just maybe, we will see constitutional conventions evolve where courts, president, and governors all start acting with more clarity and accountability, right? So if you are, as you are preparing for the UPSC and state services examination, the articles which you have to review very carefully was Article 143 clause 1, Article 145 clause 3, Article 74 clause 1, Article 74 clause 2, Article 361, Article 200, Article 201, and Article 142 and Article 131. These are all articles you should remember. That's all for today. Make sure that you revise these articles. We'll show up because they're very important for the examinations as well. So we'll come up with the next concept tomorrow.